morning. Thank you so much for joining us today. And today is a primer, everything you need to know about mediation. I think that there are some common misconceptions, both amongst the agency community and also amongst landlords, about what mediation is, the benefits of mediation and how it actually works. And the purpose of this 45-minute webinar is to give you everything you need to know so that you are better informed, so that you can inform your clients and you can understand the appropriate situations in which you will want to use mediation to help everybody involved. And there are some particularly important points at the moment, not least because of the court closure, that you will need to know about. And we've got some phenomenal guests, but we will come to them in a moment. For those of you who've been with us before, this is all well known. For anybody new, thank you very much for joining us today. You are in mute mode by default, and the reason for that is to allow other audience members to hear clearly, but we do want to hear from you. So we've got time at the end, ring fence for your questions. So whether it's a question on how mediation works or some of the use cases or anything that someone said, anything you'd like to challenge or any insights you have from practice, please do put them into the GoToWebinar box, which is on the right-hand side of your screen and looks a little like that shown on the PowerPoint slides. We do want to hear from you. So this is everything you need to know about mediation in conjunction with the wonderful people at Hamilton Fraser and the Property Redress Scheme. As usual, there is a disclaimer. So today is for general information purposes only. It shouldn't be construed as or taken as legal advice or official guidance. And now to our guests. So I'll ask you to introduce yourself. Sean, would you like to tell the audience who you are and a little bit about yourself, please?
Yes, good morning, everybody. My name is Sean Hooker. I'm head of redress of the Property Redress Scheme, and agents amongst you will be familiar that we are one of the two ombudsman schemes that are your mandatory requirements require you to be a member of. I'm also head of the Property Redress Scheme tenancy mediation service, which we're going to be talking about today, which is an innovation on and building on what we do in alternative dispute resolution and helping resolve complaints and disputes.
Brilliant. Thank you, Sean, and thank you so much for joining us. Hi, Mike. Are you happy to introduce yourself to the audience?
Morning, everybody. I'm Mike Morgan. I'm Hamilton Fraser's legal division manager, which sounds very grand, but for the purposes of today, I work with Sean on our mediation service and lead on the day-to-day operational delivery of that. So I'm a solicitor by profession, arbitrator, mediator, and 25 odd years of alternative dispute resolution experience. So trust me, there's a better way than going to court to solve a lot of these problems.
Brilliant. Thank you both so much for joining us. And so these are the topics we're going to cover off today. Again, just as a précis, our goal today is to help empower you to understand mediation as a subject, to understand the use cases where you may want to recommend mediation to your landlord clients, or if you are a landlord, to use mediation, how to understand how it works, and then to come to some of the case studies or examples as we go through. And again, we have time and we would encourage you to submit questions at the end. So just so we all start at the same point, Mike, are you happy to tell us what is mediation? So mediation 101, what is it?
Yeah, mediation as a word is sometimes a bit scary to people or something that's misunderstood. So starting point is it's a form of alternative dispute resolution. So a way of resolving a dispute without having to go through a formal legal process. So that's the first point. The second point about it is that it involves a third party. So it's not the landlord, it's not the tenant, it's not the letting agent. It's somebody who's one step removed from the dispute, from the problem, who can more usefully, I think, see the wood for the trees and understand what a solution to that problem might be. It's a bit like negotiation, but the point is it's negotiation through somebody who isn't the other side to the dispute. So it's often the case that people will be more open, more willing to be, fair and frank with the information that they exchange with a mediator. And what we're looking for ultimately is to find a solution that everybody agrees to, is happy with, and that they voluntarily, if you like, buy into. So it's not us imposing a decision, it's not us making the people's minds up for them. It's us working with both of them to find a solution that works for them from their respective positions.
Brilliant, great synopsis. So it's an alternative to going to court, or perhaps a stage before going to court, and we're going to come to that in a moment, which empowers and helps people to come to a settled agreement, and rather than a more adversarial court approach. And so, yes, I guess the key question, because some of the comments that I've seen about mediation show that people haven't really grasped why they would use it. So why do agents and landlords need mediators? Sean, would you be happy to pick that up?
Yeah, absolutely. Oh, blimey, what a lot has happened since our little journey on this started. I'm going to go back not long ago, but about a year ago, and it seems like an age ago, about why we actually were at that stage thinking of mediation. Now, we've run the property redress scheme. We've also run My Deposits, which is a tenancy deposit dispute service. We've done that through something called adjudication, which is basically evidence is provided and a neutral looks at the evidence and makes a decision. Like a judge, they examine the evidence and then they make a decision. That's not always the most effective way of dealing with things. So we were looking at, in all our schemes, introducing some form of mediation facilitated negotiation. And that's basically picking up a telephone and chatting to the two parties, or talking to the two parties, gathering the evidence there, finding out what the real core of the issue was, and then trying to bring them to a situation where they resolve the issue themselves, rather than it going and having a final adjudication done on it. So we'd already started that process. Meantime, the government was looking at other forms of redress and reform of courts and other stuff there. So it was mulling around this idea of what alternative dispute resolution services could be actually provided over and above. And then, of course, COVID hit. COVID, the whole situation closed down in terms of courts and everything else, and people were left in these insidious situations where they couldn't resolve their issues. So we decided to bring forward our plans, and our plans were already fairly advanced because we were preparing for post Section 21 world, which is basically there was going to get rid of no fault evictions and move it into some form of explaining and doing that. And part of that was mediation. So that's why we brought it forward. That's why we got it up and running. So it's not just COVID. It's Section 21 reform and other things that are going to make this more and more important in the way that we deal with disputes and complaints ongoing.
Brilliant, thank you. And Mike, I want to put the more thorny question to you, I think, which is, given some of the perceptions around mediation, why is mediation better than alternatives? So as a landlord, why would I use mediation?
So I think the two big points are, firstly, speed. The alternative to mediation is that you're probably looking at court proceedings. So we know how long that's taking. We know the problems around getting possession orders and also enforcing those through bailiffs. So if you want to wait up to a year and see how you fare in court, that's your alternative. So much quicker with mediation, much lower cost than court proceedings. And it's also consensual, which I think is a big point. What we're saying here is we're finding decisions that both sides are happy with. If they're happy with the decision or the solution, they're going to stick with it, much more likely to follow it through because it works for them and it's to their advantage to do it. Give you one quick example of a case that we had with a landlord who was prepared to negotiate for rent arrears, but was being quite strict about how long they were prepared to give a tenant to pay those arrears back. And the tenant couldn't afford to do it at the rate that the landlord wanted. What was really important to them, though, was that they wanted to stay where they were because the kids were in school and the parents didn't want the upheaval of having to move. So a little bit of creative thinking, a little bit of exploring around how we could find a solution that worked. What ended up happening in that case was that the tenant was able to find a loan which repaid the arrears. They could get a lump sum quickly, which would repay the arrears in a single sum. It was affordable to them as a form of credit, if you like. It gave them a period of time to repay the loan, which was easier and over a longer period of time than the timescale that the landlord was looking at for the repayment of the arrears. But you scratch my back, I'll scratch yours. The tenant said, if I'm going to repay this money in one lump sum and it's going to take me a year to repay the loan, how about giving me another 12-month fixed term tenancy so that I've got the certainty of staying where I am, the kids are at school, and everybody knows where they are. And that was the outcome that everybody was happy with. You know, this tenant had never been in problems before. It was all down to COVID, and lots of history there to show that once they got over that bump in the road, things would carry on as normal. It was a nice, you know, creative solution that worked for everybody.
Absolutely brilliant. I think we are in unusual times. Hopefully some of the positive news over the past 24 hours indicates that there may be light at the end of the tunnel and we'll be returning to a more normal world. But in a period where there is upheaval both to the economy and businesses, and also court closures, and I'd like to come back to that, Mike, I think that creative problem solving has heightened value. Now, just sort of harking back a few years to my life as a lawyer, in typical litigation, parties are encouraged to avoid court and to seek to come to some form of alternate dispute resolution mechanism, and lots of contracts have them in. What's your perception about how courts would view people who've gone through a mediation process, or I guess from a landlord's perspective, at least trying that? When the courts reopen, there's going to be a backlog of cases. Do you think that's going to feed into how cases are prioritised in any way?
I think it will be. I mean, yeah. Look at it this way, there's going to be a massive backlog of cases, and there's also potentially another sort of tsunami of cases coming into the system. The courts can't deal with all of those together, so they're going to have to look at ways of prioritising which cases they deal with first. We know they've talked about the most sort of egregious cases of rent arrears and antisocial behaviour and so on being the ones that are at the top of the tree. But with all the others, what else could they use as a means of prioritising? And I think looking to see whether people have tried to solve it before coming to court is almost certainly going to be something that the courts look at. If I'm, as you know, me as a judge or me as a court officer looking at that queue of cases, which are the ones that people have tried to sort themselves? If they've tried that and failed, let's get involved. If there's no evidence to show they've done that, we're not getting involved. I think that's definitely going to be the approach that the courts take. So it's about getting your case match fit as much as anything else. And even when mediation fails, I think the way to think about this is that it's still a win. You know, if I've attempted mediation, I can show that I've done it, I'm still in a better position than I would be if I never bothered. I think that's the mindset that we need to encourage landlords to adopt. You know, this is a win either way. And in its best form, I may not need to go to court at all.
Brilliant. So, best case outcome from mediation is you resolve the dispute in a creative way. Middle outcome is you narrow the gap between the parties and create a better common understanding. And the very worst is you've shown a genuine effort. I think it has to be a genuine effort rather than sort of going through the motions to try to resolve it, and you've got your case match fit and you're more likely to be heard easily, more quickly. And I think that sort of understanding of even the worst case scenario for mediation is something that, because it hasn't typically happened in the sector, I don't think people have really grasped, but it should be beneficial whatever the outcome.
I think that's right. And one of the things that we hear, perhaps more so with letting agents and landlords, but one of the things that we hear people saying is, well, it's just negotiation, we can do that. But I think the point here is it's more than negotiation, and it's using somebody who's not a part of the dispute. Remember we said about that third party who's one step removed. And this comes across all the time in the conversations that we have, particularly with tenants. You know, they'll say, can I be honest with you? You know, if I tell you things, will you tell the landlord? Well, not necessarily. You know, we treat it as confidential, which encourages them to open up and be frank and be honest with us. Of course, there's some things we've got to share with the landlord if they're, you know, making a proposal for how they clear the arrears, what the time they think they'd be able to take to do it, and so on. But the point is, people open up to us, which I don't think they will do in quite the same way when they're on the end of the phone with somebody that possibly they're in conflict with or have already had an argument with. It's a fresh beginning and a fresh set of ears that mediation brings.
Absolutely brilliant. So I'm just checking, and there are some questions coming in. So we've talked about what mediation is. So if you've got any questions about mediation, sort of the basics of what mediation is, or in fact why you might want to use it or recommend its use, then please put those in. We're going to move on to how mediation works, and then I want to poke at this a little bit and just sort of ask the questions that I suspect the audience may be asking, or some of the questions that have come in before about, does this actually work? So we'll come on to that. So in terms of how does it work, so how do mediators help resolve rent arrears or other tenancy-related disputes? And are there any examples you can give? So Mike, you said sort of being that independent party in the middle is useful. One of the pushbacks I would expect you to face is this is a highly emotive issue. On one side, you've got someone's largest asset not being paid for if it's rent arrears. On the other side, you've got someone who may have lost their job because of situation beyond their control, who risks losing their home. So really, really high intensity, high emotive situation. So how does it work? If you could step us through the timeline. And then also, perhaps Sean, can you talk through how you de-escalate the situation to actually have a shots of success through mediation?
So first step is that the landlord will instruct us to mediate. We'll ask them to give us background information about the tenancy, obviously usual things like how much the rent is, rent statement, how long has it been unpaid, what the arrears are, and so on. What we call step one, where we approach the tenant to get their consent. Currently, we're offering that as a free process, so there's no charge for doing that. And we find, certainly in more than half the cases that we're dealing with, tenants do agree to have that discussion. So that's good. We do that probably within 5 working days. We're finding at the moment it's generally within 1 or 2 working days we've been able to get hold of the tenant and find out whether they're willing to engage in the process. Where we get to that point, the active mediation itself, we aim to do that within 10 working days. So remember, we said it's quick. You know, you're not going to get through a court resolution in 10 working days. Mediation you can do. It's nice and quick and fresh and current, I think, is the best way to describe it for both parties. If we get to the point where there's a formal agreement, we will document that in a legally binding document which both parties sign. So there's a record of what the terms of that agreement are. If mediation doesn't work, then we'll produce a certificate or an attempts to mediate report, which essentially shows what steps the landlord has taken, tenant's taken, we've taken to try and get to that agreement. What other costs are involved? If we get to an active mediation, currently we're offering a discounted service where we charge £200 for the mediation, and that's it. So worst case scenario, it's going to cost you £200. The lowest cost would be that if a tenant doesn't consent to mediation, we'll just do a attempts to mediate report, which costs £25. That's that certificate which gives you that seal of approval, if you like, so that when you do come to any court proceedings, you can show that you've done what you can to use an independent mediator to resolve the dispute. So headline points: free in many cases, £25 if we can't get a tenant to agree to mediate. If they do agree to mediate, worst case scenario is it will cost £200 and no more than that.
Thanks, Mike. We're going to come to Sean in a second, but one of the questions that's been flagged a few times is, why does the landlord pay and not the tenant? So could you just explain who pays and why?
So remember we said mediation is reaching a consensual agreement. It's possible to agree what happens to those fees as well. I've certainly had some cases Not many. I'll explain why not many in a minute. But we've certainly had some cases where the parties have agreed to split the costs between them, so they're both equally paying something. We have had a handful of cases where landlords have said, I want the tenant to pay the cost of mediation. We can certainly pitch that to the tenant if that's what the landlord is asking for. But the practical reality is, in those cases where landlords say, I want the tenant to pay for mediation, they are almost certainly unlikely to want to play ball. That's the practical reality. Cases where it's split or shared, possibly more likely, but having said all of that, our experience is that the majority, if not all of the landlords that are coming through the mediation route, see it as a not significant cost, but one that they're prepared to pay because it's better than the alternative. You know, if I can get this solved for 200 quid, what am I saving myself? Months and months and months of aggravation, much more cost, much more time, much more delay. So again, I think it's about a change in mindset, a bit like sort of speculate to accumulate. If I can get this solved for 200 quid, much, much better than the alternative. If I can't, it's put me match fit for when I do go to the court process. About a change in mindset, I think that it's important to get across.
Brilliant, thank you, Mike. And Sean, can you talk us through a real world example of rent arrears? So, in my head, if a tenant hasn't paid rent and they're risking losing their home at some stage, it'll be highly fraught for them. A landlord at the other end not receiving perhaps their only or main source of income is also highly fraught. How do you de-escalate that to even get close to getting an agreement?
Well, absolutely, Raj. That's always the it's one of the criticisms that people make against mediation. But is it its strength? Is it actually does deal with the emotional side of it, the feelings. It is about being empathetic. It is about kind of understanding the situation from my perspective and your perspective. That's very difficult when you're in conflict. People take positions and they stick to those positions. I'm right, and I'm going to take that position. And it's our job to bring the parties round to seeing it from the other person's perspective. So that does mean that you are dealing with some real life emotional situations. So we had a case here where lockdown started. Immediately the tenant went into arrears. He then scrimped and scraped, borrowed from relatives and other things to keep paying his rent. Now this guy was self-employed. He was a barber. Of course, nothing was going on during lockdown. We couldn't get a haircut, so I grew a beard. I've still got the beard, and our hair, grew. So this guy wasn't working. So the landlord was there, was saying, actually, but I've got to pay my mortgage. I've got to, to maintain my costs. So when we got to sitting down with the parties, and we did it separately, the guy really wanted to stay in the property. He liked the area. He liked the landlord personally, but he just physically could not catch up with his rent. So we took him through and said, well, will you be able to keep paying your rent ongoing? He said, yes, but I won't be able to pay the extra. But I do want to stay in the property, and it's coming up in next March, and I don't want to leave the property. And now the landlord kind of lost a bit of trust in me, but I want to restore that. So we spoke to the landlord. I said to the landlord, well, actually, they are paying their rent at the moment. Now look at it from your perspective. You're holding 6 weeks deposit, so that gives you some form of security there. So you're not going to be out of pocket if we can keep the tenant paying the rent. Park the arrears for the moment. Okay, agree with the tenant when you would like that to be paid back, and see if you can continue that relationship. They're good tenants. A good tenant doesn't become a bad tenant overnight because of circumstances. So if you understand the circumstances, and we help the parties to understand that circumstances, you can move on, and you can end up with a stronger relationship. So it is about kind of us being able to reach the parts that other conversations are not going to get, because people have, they don't want to admit necessarily that that they are they can't afford something, or they feel intimidated, or they feel awkward in dealing with each other. We can overcome that because we've not actually got the parties in the same room kind of confronting each other. We've got them separately. They can share things with us confidentially, and we can kind of let them explore their options without being under pressure, and find a solution.
Really interesting. And I keep looking away because I've got another screen with the questions coming up, and some of the audience questions are phenomenally good head scratchers. So I'm quite looking forward to those. A couple of curveballs in there. Just before we come to that, I've got the very blunt question. Mike, you've already talked about getting match fit, but one's mediation doesn't work. So I paid my £200 as a landlord. I haven't got anywhere. I've got my certificate. What do I do next? So Mike, Sean, either of you, if it doesn't work, and it's not going to work in every situation, I think we've got to accept that. Mike, you talked about the benefit of being match fit. Is there anything you'd like to add to that? And then Sean, I'm a landlord. I paid £200. What do I do next?
Well, I think what the courts are certainly looking for is evidence to show that the parties have tried to resolve a dispute. They're also wanting to see that a landlord who's taking legal proceedings against a tenant has taken the time and trouble to understand what their circumstances are and whether there's an alternative solution. Now, it's all very well for a landlord to say, yes, I've done all that, I've spoken to the tenant, and here we are. But I don't think that's going to cut it with the court. So the benefit of having this independent, if you like, sort of third-party certificate to say you've been through this process and you've explored these avenues means that when you do come to court, that certificate is something you can produce as part of your evidence pack, if you like, to say, I've done the alternative, I've done everything I can. Now we need to move through the sort of formal legal process. I think there's another benefit as well, though, which is that it shows to a tenant that you're open and willing to discuss things. And there have been some cases where mediation, within that sort of short 10 working day timescale, hasn't always worked. But what's interesting is we've seen some people come back a bit later and say, actually, can we have another go? Or tenants realise, actually, there is a way forwards here. I can agree something with the landlord. So all is not necessarily lost, I would say. Gets you match fit for the court proceedings, but also it just leaves that door open to show that you're willing to discuss things, you're prepared to negotiate. And I think that's useful in itself because it makes tenants more willing to come forwards as opposed to feeling they're in an adversarial situation where they're frightened to do or say anything.
Amazing. Thanks, Mike. And we've got a lot of questions in, guys. So this will be the last bit before we go on to the audience questions. I'd like to cover as many as we can through them. But Sean, just very bluntly, if mediation doesn't work, what then?
Well, if we've learned one thing over the last 10 months is that there is no magic wand for problems, and that the way you now have to approach things is in a multiple way. So what we're saying is that mediation is, it's got a higher likelihood of success if you can get the parties to sit down and talk together, and the parties enter into it in the right spirit. Now, that's not always going to happen, and you are going to get obstructiveness from one party or the other. So we thought about that, and we're thinking, well, actually, the one advice we would give to a landlord who's trying in the situation and wants to take it forward is, yes, give mediation your very best try. However, keep your options open. Okay, you still have the option to go to court. It's a lot more difficult now, so you're not going to necessarily find it an easy path to negotiate or to navigate. How can we help with that? Now, as a lot of you may know, that the Hamilton Fraser Group, as well as running the property redress scheme, owns and runs Landlord Action, which is one of the country's foremost eviction specialist companies, SRA regulated and legal firm, with qualified lawyers working every day to help landlords to find their solutions to their arrears and possession problems. So what we decided to do is to partner up with Landlord Action and to offer a proposition which, on one hand, you are entering into the mediation service, okay, and trying to give that your best shot to try and resolve that. Not only will that have a very good chance of success, it will also allow you to have your ducks lined up for the courts to show that you've actually been through the process. At the same time, we will start the court process, which is now a much more lengthy and complicated situation. So we will start in tandem what was called stage one of a possession process. So we'll serve a notice, we'll get the papers ready for court, and it will only be with the mediation failed that then we're actually ready and to actually get a case up and running. So there's no time lost. You don't actually have to wait for mediation to finish to actually start the process. They can run in tandem, we can coordinate it, and whichever is the best option for you, we can take that forward. And we're managing to do that because we're the same parent company. We can do that at the most cost-effective and coordinated way. So that's our solution to it. So certainly, please explore that when you are looking at your options. You don't actually have to do either or. You can do both together.
I think it's sort of carrot and stick, isn't it, Sean? Or a great way of focusing people's minds. You know, in those cases where notice has been served and mediation is offered as an alternative, we do see a much higher take up with tenants because they realise, you know, this is not going to end well, come what may. So let's see what I can rescue from the situation as a happy solution that we both agree to, rather than me going to court and getting slung out.
Thank you very much, guys, and thank you very much to the audience for all of the questions. If you've got any pressing questions off anything you've heard, please do put them in. We're up to a page of questions, so I'm going to try and deal with some of the quicker ones and then chuck a couple of curveballs at you from the audience. So, Mike, on average, how long is the duration of a typical mediation? So, from the initial, I would like for you to get involved, to an outcome, whether that is a settlement or otherwise, what's the typical time frame that a landlord would be looking at?
So we're averaging less than 15 working days in total, but we are seeing at the moment some of the cases are going through in 10 days and less. So it's quick. It's quick. As I say, a lot of cases we're getting hold of the tenant within the same working day or the next working day, and then we're into that sort of 10 working day cycle to try and reach agreement with the tenants. So we, you know, certainly talking days, not weeks.
I'm not sure who would be right to answer this, so just whoever wants to, please do, which is this an initiative by court services like small claims, or is it a private initiative? And I think this is clearly a private initiative. So will it actually be recognised by the court when you produce your certificates?
It will be, and I think that the big point to take away from this is it's mediation that's offered through the property redress scheme. And the property redress scheme is one of the government recognised bodies for providing dispute resolution within the private rented sector. We can also demonstrate that the people that actually do the mediation are qualified to do it, but the PRS name is recognised by the courts as an ADR provider.
Yeah, absolutely right. I mean, ironically, tomorrow I've got a telephone call directly with the civil servants at the Ministry of Housing to discuss through the benefits of what we're doing and to see how we can more closely coordinate it. We've already had our scheme mentioned as in some of the guidance as a kind of an alternative route. So although it's not approved as such, it is certainly something that the government is encouraging people to use. You know, organisations like ourselves with the credentials that we have behind us, as Mike says, and that's very, very important. So, we're not the only ones out there, but if you are going to use an alternative, make sure that you go through your due diligence on the sort of company you're going to be using. And
I think certainly our expertise in the private rented sector,
absolutely,
not all mediators will have
that. So, so we're not saying that we are the only source, but we believe we tick all the right boxes and can do the best job for you.
A really interesting, thank you guys. A really interesting questions come in, which is so we talked about if this is landlord initiated and the tenant refuses to engage, that's indicative of the tenant's lack of willingness to solve the problem, absent a court, and it may help the landlord to get their claim to the front of the queue when the courts reopen. Can tenants initiate mediation? And what do you think the impact would be if the landlord then refused to engage in the mediation process?
Well, funnily enough, just in the last week or so, we have had a case where a tenant said, I want to ask the landlord to mediate. And we've essentially done the same process, but the other way around. So tenant has instructed us, we've approached the landlord, tried to get them to understand the benefits of mediation. In that particular case, the landlord wasn't willing to engage, and same process applies. We produced a certificate for the tenant to say, I've tried to find an alternative solution to this with my landlord, but they're not willing to participate. So it can work both ways.
A couple of questions have come in about neighbours, and so I'm going to break them because I think they're two different scenarios. So the first is, can mediation be used to resolve a dispute between a tenant and a neighbour who is not the landlord? So would mediation operate in that context? And then separately, what happens if there's a noise dispute between the tenant and their neighbour who is their landlord? So where would mediation fit within that, and how would you guys work?
Well, I think at this stage, that's a very interesting question, because we've been asking the same questions to ourselves as we've been evolving this scheme. Potentially, mediation is a very powerful tool for any tenancy dispute. And one of the things the government have been looking at, for example, is moving mandatory redress, which agents have to be part of, to extend it to all landlords. And that is a process that has been at the back of our minds for a while, and we've been actively looking at how we would apply a redress scheme for landlords. So any dispute, I think, where there is a disagreement between a tenant and a landlord, or even a third party, in a shared block, for example, the antisocial behaviour and other stuff, mediation can be applied to. And we are certainly open to looking at all disputes that are coming in and applying the same mediation model to it at the moment. This will evolve, I can tell you this now, that alternative dispute resolution, we've just been through lockdown, we're just going through government spending an awful lot of money. The courts are not going to actually have an awful lot of time or money to deal with a lot of disputes that normally in the past they might have done. And we can actually provide a service that is cost effective and it works for both parties, and can actually in many cases get a much better result.
I think that's right. And as Sean said, it's interesting, in some of the disputes that we've had already, they start off as typical, rent arrears or I want my property back, and they end up something quite different. So one of the cases which has been particularly interesting in the last week is a tenant who agreed that they should leave the property because they were unable to continue to pay the rent. But what they'd also done during the tenancy is move their elderly mother into the property as an unauthorised occupant, and the tenant agreed to go, and they left. But they abandoned their mother and left her behind in the property, thinking she's not on the tenancy agreement, she can't be evicted, she's safe, she's got somewhere to stay, everybody's happy. And of course, everybody isn't happy. So it became quite a different tack to that mediation, having to talk to mother and understand her circumstances, poor old thing being caught in the middle and used as a bit of a pawn against the landlord. it all came right in the end. You know, mum was able to move out and find somewhere else to live, but you know, started off as a rent arrears dispute and ended up as a bit of a, you know, screw you, I'm going to leave my mum behind and make your life difficult.
Gents, thank you so much. The questions are still coming in. I think that what I would like to do is just sort of, a lot of the questions that have come in that we've not addressed are very fact specific. So people will sort of say, I've got a tenant with X level of arrears or a factual scenario. I think the most useful thing is at the end of this, you're going to get the details of the PRS mediation services and automatic email follow-up. And I'd suggest with those fact specific things, if you're happy to, get in touch with Mike and Sean or their teams with those contact details and talk through whether mediation would be appropriate for your scenarios. Because I think rather than go through all of the fact scenarios for each of them, that would be probably the most useful thing. And a couple of people have asked some more detail about the scheme, including who are the mediators involved, how are they trained, how are they accredited. So again, for those sort of specific questions, I would go back to Mike and Sean. Just before we close up, is there one thing that you want to share with the audience before we wrap up? Mike, what's your sort of key takeaway?
I think the key takeaway that I would say here is, remember, this is an alternative to having to wait months and months and months to get your case dealt with in the court process. We're talking about a quick win, whether it's a win by a certificate that says I've tried to do all the things the court expects of me, or a win, we come to a solution that works and everybody's happy to agree to. Remember that alternative, months and months and months, lots and lots of cost and time. And not only that, delay, arrears continuing to increase in the meantime. So bite the bullet, use the alternative because it works.
Brilliant, thanks, Mike. And Sean, what's your key takeaway for the audience today?
The key takeaway is that this is the new normal. This is going to be the future. Things are not going to go back to where they were. Government's already pledged that it will get rid of Section 21 and reform the process. The government is very keen on alternative dispute resolution and non-court-based solutions, and that you know, there are people out there that can help you, and that's the point. You're not on your own. You know, there are organisations out there that are there to help you to manage this forward. Don't try and think you can do it all yourself, because the consequences of it could be very serious. Do your homework on who you ask for help, but ask for that help. If you ask for that help, it will be given. And it is possible.
Hogwarts always helps those who ask for help. Thank you very much, Sean Potter. Gentlemen, thank you so much. Just a couple of things, a bit of housekeeping. So you're going to everyone will get a follow-up email within 24 hours with all of the details of the service and some background information. I believe some case studies will also be included, so look out for that. This is our last webinar of the year, absent a further last-minute government change in rules, regulation or legislation. But we're looking at topics that you might find interesting for next year. So we're building out our webinar calendar for next year. If there's anything that you think would be useful, please do email us to, it hasn't come up on screen, research@fixlow.com, or just put a comment at the end. Mike, Sean, thank you so much for joining us. Really delighted for you to give us a 101 on mediation, and to the audience also for joining. If we don't speak with you before, have a wonderful Christmas. If we do speak with you before, it's because the government's changed something. So I hope everyone stays well and healthy, and catch up soon. Thank you very much for joining. Bye.
Thanks, everyone.